On 1st July 2024, the three new criminal laws, namely the Bharatiya Sakshya Adhiniyam, Bharatiya Nyaya Sanhita and the Bharatiya Nagarik Suraksha Sanhita came into force in India. Last year, when the draft bills of these three new laws were presented in the Parliament to replace the IPC, CrPC and the Indian Evidence Act, it created an environment of confusion and uncertainty. These laws aim to modernize and enhance the Indian legal framework. The laws not only affect the legal fraternity but also every individual and citizen of our country. Well, if you are interested in knowing about the three new criminal laws and the changes they bring, then this video is for you. Hello everyone, I am your host Urvashi Chauhan. Welcome to this limited series by Live Law on the new criminal laws. Live Law will be bringing to you a series of videos explaining and doing a comparative analysis of all the three new laws in English and in Hindi. First of all, let me tell you that the scheme of sections that you spent hours on remembering in all the three laws has now been changed. All the three laws contain the repeal and savings clause, which ensures that with old act being replaced by a new one, existing rights and obligations under the old law are preserved without disturbance. So for some time, there will be a parallel application of both old and the new acts. Ever since the laws were passed, they have received criticism from all walks of life, including from legislators, members of opposition, civil society, journalists, and non-governmental organizations. They have been termed to be the same old content with new names. Though the government has been positive that the new laws are to update the Indian criminal law system with time, the hasty implementation, major oversights and vernacular titles are all going to impact every institution of the country, especially courts, which have spent years in settling the jurisprudence that India today has. We start this series with the explanation of the new Evidence Act called the Bharatiya Sakshya Adhiniyam 2023. The most significant changes in this act are consolidation of sections and removal of colonial era references, while keeping the structure similar to the existing Evidence Act. Let us trace these changes one by one. The BSA has 170 sections and 12 chapters as compared to 167 sections and 11 chapters of the Indian Evidence Act. Starting with the change in the first section, previously Section 1 of the Evidence Act specified that the Act applied to all of India. However, Section 1 of the BSA does not include this specific provision. This has likely been done to facilitate acceptance of digital evidence created outside of India. By not restricting BSA's application to within India, it allows courts to consider digital evidence from other countries, which is important given the global nature of digital communication and data. Unlike the Indian Evidence Act, the BSA now applies to court-martial convened under the Army Act, the Naval Discipline Act or the Air Force Act. Section 2 of the BSA has modified the definition of the word document. This definition now covers a diverse range of electronic records, including emails, server logs, files stored on computers, laptops or smartphones, text messages, website content, location data, voicemails and messages stored on digital devices. The definition of evidence under Section 2E of the BSA has been updated to include statements given electronically. This change recognizes that many communications happen digitally and should be considered as evidence. To reflect this, the entire BSA now uses terms like digital to include electronic records in its provisions. The definitions of words may presume, shall presume and conclusive proof, which were earlier under Section 4, have been brought under Section 2, that is, definitions. Moving ahead, in the new Acts Chapter 2, Section 22, there are important changes as to how confessions are handled. Originally, any confession made under threat, promise or pressure was considered invalid. Now, two new rules have been added. First, a confession can be valid if the court believes that such pressure, threat or promise has been completely removed. And second, that a confession does not become invalid just because it was made with a promise of secrecy, obtained by tricking the accused or the accused was drunk, etc. Section 22A of the old Evidence Act dealing with oral evidence as to contents of electronic records has now been excluded. Coming to the next provision, that is regarding joint trial. Section 24 of the BSA, while keeping the same text as of Section 30 of the Indian Evidence Act regarding joint trials, has added a new explanation. It states that a trial involving more than one person will be considered a joint trial even if an accused person is not present because they have either absconded or have failed to comply with a proclamation issued under the Bharatiya Nagarik Suraksha Sanhita or the new CrPC. Section 32 of the BSA now recognizes electronic or digital versions of law books and court rulings as relevant evidence. This applies if these digital law books or reports claim to be printed or published under the authority of a government and contain the laws or court rulings of that country. This means that digital copies of legal materials are considered valid evidence when a court needs to form an opinion on the law. Coming now to Chapter 3 titled On Proof. The first change can be found under Section 52, which mandates that courts must recognize all laws in effect in India, including those with extraterritorial reach. This provision was absent in the previous Act, which only acknowledged all laws in force in the territory of India. But now the BSA requires courts to recognize international treaties, agreements, or conventions involving India, decisions made by India in international associations or bodies, and seals of tribunals alongside court seals. Next, we talk about expert opinion, which, as you know, was under Section 45 of the Evidence Act. With advancements in modern science, opinion from experts have become increasingly relevant in the justice system. Although not conclusive proof, they are important in helping courts make decisions when they support other evidence. The BSA retains the provision as in Section 39 with addition of the phrase "or any other field." This change allows courts to rely on expert opinions in any field that might be necessary and not just the limited areas that were previously mentioned in Section 45 like handwriting, science, or foreign law or fingerprints. Let us now proceed to see the changes under Chapter 5 of BSA, that is documentary evidence. The new BSA classifies electronic or digital records as primary evidence under Section 57. In the old Indian Evidence Act, primary evidence meant original records, while secondary evidence was used to prove the contents of the original records. This change acknowledges the move from paper-based systems to electronic communication and data storage. Section 58 of the BSA now includes oral admissions, written admissions, and evidence from a skilled person who has examined complex documents as types of secondary evidence. Previously, oral admissions about document contents were allowed under specific conditions related to the document's genuineness. Written admissions were admissible if they confirmed details about the original document's existence or contents. The BSA now explicitly categorizes oral and written admissions as secondary evidence. This means they can be used as evidence in court, but the rules governing when they are admissible remain the same as before. So, the BSA has expanded the types of evidence considered secondary while maintaining the conditions under which these admissions can be used in legal proceedings. One thing that I must add here is that with the advancement of technology and artificial intelligence, means and modes to tamper with electronic evidence may have increased. There is a likely possibility that false evidence can be generated by the use of artificial intelligence. Thus, for secondary evidence to be admissible, legal experts have suggested that an affidavit in support should be required. Next, Section 63 of the BSA continues to require a certificate as specified in Section 65B of the Evidence Act whenever electronic evidence is presented in court. The updated provision now mandates that this certificate must accompany the electronic record every time it is presented. It allows the certificate to be provided either by the person responsible for the computer or communication device or by an expert, and removes the requirement for a person in an official position to provide the certificate. Also, in contrast to the Evidence Act, which did not specify the format for the certificate, the BSA now introduces Schedule A and Schedule B. Part A is filled out by the party presenting the electronic or digital record, and Part B is filled out by the expert who confirms digital fingerprints using specific algorithms provided directly in the form. Section 80 of the BSA assumes certain documents like official gazettes, newspapers, and those required by law to be genuine if they are kept and presented properly. It defines proper custody as where and by whom the document should be maintained. Even if custody seems unusual, it can be accepted if the document's origin is proven or if circumstances suggest that it is likely authentic. This applies equally to electronic or digital versions of official gazettes. Next, let me tell you Section 85 of BSA, which speaks about electronic agreements affixed with electronic signatures of parties, and Section 86, which speaks about electronic records and electronic signatures now include digital signatures in addition to electronic signature. Proceeding to Chapter 9, which talks about witnesses. Under the old Evidence Act, there was a conflict regarding accomplice testimony. Section 133 earlier allowed the uncorroborated testimony of an accomplice to be used in court. However, illustration B of Section 114 suggested that an accomplice's testimony was unreliable unless it was supported by corroborating details. The BSA resolves this conflict with Section 138, which now states that an accomplice can testify against an accused person. And a conviction based on corroborated testimony of an accomplice is legal. This means that BSA now requires corroborating evidence to support an accomplice's testimony for it to be considered reliable in court. Another important change we see is in Chapter 10. The BSA, with the proviso to Section 165, includes a provision stating that no court can demand production of any communication between ministers and the President of India. This contrasts with the Evidence Act, which did not have any such provision. The introduction of such a provision in the BSA could potentially lead to abuses of power, as it might prevent judicial oversight of administrative actions. This could allow governmental decisions to proceed without sufficient scrutiny, raising concerns about accountability and checks on executive authority. So these are some of the major changes that the advent of the new Evidence Act brings. You will also find that the structure of many sections has been changed now, but the meaning and substance of the provision is the same. In addition to these provisions, the BSA updates various terminologies to be more relevant. For example, coin is now currency, carriage is now cars. Government of India is now state, and city names like Calcutta are changed to Kolkata, Bombay to Mumbai, and Kabul to Singapore. In illustrations, monetary amounts like 1,000 and 1,500 rupees are now represented as 1 lakh rupees and 1,50,000 rupees respectively. While the Act aims for uniform standards in interpreting similar subjects and equating the status of electronic evidence experts with other experts, certain provisions, especially those regarding confessions and document production, need closer scrutiny to understand their full impact and effectiveness in practice. Most fundamental principles in India's evidence law, such as burden of proof and relevancy of facts, continue to remain unchanged from the over 130-year-old Indian Evidence Act in the BSA. Yet, the BSA marks a notable shift by prioritizing electronic records. This move does signify India's legal system adapting to modern technology, but the real test lies in how swiftly and effectively courts, lawyers, litigants, and investigating agencies will adopt these changes. The real test in making the legal system genuinely contemporary in practice is at the ground level. Thank you for watching. This was part 1 of the series. Stay tuned with me as I bring you insights on the other 2 important legislations, that is the BNS and the BNSS. Keep watching and keep learning with Live Law.